All right, we've got a few more in there and we might get started. Welcome everybody. My name is Daniel Carroll. I'm from Master Plumbers. Thanks for joining us today. We've been lucky enough to get Richard Hutchings from Cornwalls on today to lend us some of his valuable time and give us a few tips and tricks around getting paid in the age of COVID. So really appreciate you lending us your time, Richard, and I'm sure everyone on the call does as well. As I said before, we're recording this session, so don't despair if you miss out on anything and want to go back and review it later. We'll send out a link via email, so you can even forward this to other members of your team and check it out at a later stage. We might have some time later on for some Q&A, so if you've got a question in regards to anything that happens during the presentation, there's a chat bar down the bottom. You can put forward your question and we might put aside some time later on to go through a few of those. So without further ado, I'll hand it over to you, Richard. Thank you very much.
Thank you very much, Daniel. Good afternoon, ladies and gentlemen. The topic for today's presentation is tips and tricks to getting paid in the age of COVID-19. With the likely relaxation of COVID-19 restrictions and the move to what's called the second step on the roadmap towards COVID normal, as they call it, this subject is particularly relevant. The topic, I think, is also pretty relevant because many participants in the construction industry have been doing work in recent times and have been having trouble getting paid. As you know, you don't need a lawyer to tell subbies that this is a problem across the construction industry in general and has been for as long as you've been doing work. But with COVID-19 has come some legislative changes in the insolvency area. And I think it's fair to say that whilst they've come with benefits, it's made the issue of getting paid and that problem just that bit worse for all of us. So that's the presentation today. As Daniel mentioned, at the end, I'd like to have 5 or 10 minutes for questions, and all up, I expect that this will run for about 45 minutes. So quick introduction, my name's Richard Hutchings, partner at Cornwalls. I'm involved in the construction field. I do both front-end work, i.e. contract drafting, terms and conditions, that sort of thing, and also back-end dispute work, so chasing money that's owed, but also other contractual disputes that come up from time to time. So what are we talking about today? Well, this is the subject matter that we will be covering in broad overview. So the COVID-19 legislative changes, the appropriate contract that you should be entering into and the importance of a contract. I'll talk about master plumbers to standard form contracts, how and when to use them. I'll then go into the tips and tricks for getting paid, what you should be thinking about and perhaps doing to try and mitigate the chance that you won't get paid and to try and get paid. And then I'll look at a few things dealing with particular issues such as variations, latent conditions and the like. I'll also touch on the issue of when you can stop work or suspend work until you're paid. Then I'll talk a bit about recovering debts, how to go about doing that. If there is a problem and you're not paid, what can you do to get paid? And finally, I'll look at a couple of practical examples, which will hopefully draw upon some of the content today and serve as useful examples for you, in terms of day-to-day examples. So let's start with COVID-19 and the legislative changes. What are they and how have they impacted upon the industry? Look, I'm conscious that legislative changes are not the most fascinating thing to talk about, particularly for subcontractors, but just generally. But we do need to go into it in a little bit of detail because these changes have impacted on the issue of cash flow and getting paid amounts that are owed to you. So as you probably know, when COVID-19 arose back in sort of March, the federal government and the state governments, but we're talking about the federal government with regards to insolvencies and the laws around those insolvencies, passed some legislative changes. And the key change is in the past, if you were seeking to be paid an amount of money by a company or a person, you'd go and you'd get a judgment, you'd enforce under security of payment, you'd get a judgment registered if you won that process, and then you'd go and enforce it typically through either a statutory demand in the case of a company or a bankruptcy application in the case of an individual that owes money. Now, in the past, that would mean that when that statutory demand was issued, or that bankruptcy application was issued by your lawyer chasing your debt over $5,000, there'd be a 21-day window for the person receiving it, the debtor, to either pay it in full or come forward and do a deal with you or have it set aside. The 21-day window. So there's a fair bit of pressure there once you got your judgment for the other side to cough up effectively. Now, that law changed with the COVID-19 insolvency reforms, and with the desire to protect individuals and companies from being put into insolvency because of debts, given the cash flow problems that a lot of people are experiencing. The government did two things. One, it increased the amount from $5,000 to $20,000 as the threshold before you could issue a stat demand or an application to bankrupt someone. And secondly, and perhaps more significantly, the period of time for a debtor receiving a creditor's petition or statutory demand has increased from 21 days to 6 months. And that's been referred to as the 6-month temporary debt protection. Now, that's a pretty significant change. The intention there was to give companies and individuals more time to pay their debts and to stop a wave of bankruptcies and insolvencies that might have otherwise been created by all the problems in the economy due to COVID-19. I mean, I won't go into that, but we know all about that. Shutdowns of industry sectors, retail largely closing down, people losing their jobs, people losing contracts, etc. The reforms started on 25 March, and they were originally slated to end at the end of this month, September. However, due to recent developments, the second wave in Victoria, etc., the ongoing shutdowns across Victoria, but in other states, these reforms have been extended to 28 March 2021, so 28 March next year. I think it's fair to say that these reforms are useful or helpful to you if you owe money, because it gives you more time to pay. So that's the benefit. But of course, the downside is that they can and obviously will and have been used by people up the chain, so builders and owners, to avoid paying people down the chain for construction-related works, materials and services. And I think the short point is these reforms are open to abuse. So you need to understand this reality before we can look at the rest of this presentation, which is this issue of getting paid. You need to understand that the law has changed significantly and it can be abused by people that owe money, by debtors. And you need to understand that before you look at the tips and tricks to mitigate the risk of non-payment. So let's move forward then and look at the importance of entering into an appropriate contract. Lawyers will always say this: have a contract and have an appropriate contract for anything that you're doing in life. And that's very true in many contexts, but in particular in the construction industry and for subcontractors, including plumbers. Now, how does it work? Well, obviously, have a document that sets out the basis of the relationship. That's the aim here. We know quite well that builders or sophisticated principals and owners may well seek to impose terms and conditions of a contract on you as the subcontractor. I'm sure you've all seen those usually quite lengthy standard subcontracts that builders and others put to you. That's what often happens. If that happens and a contract's put to you, then you should get legal advice on that contract. Think about whether any special conditions can be negotiated to assist you. For example, what is to payment terms, make it more favourable payment terms. Think about limiting your liability. What about force majeure for COVID-19, i.e. extensions of time for delays outside of your control, etc.? What about the issue of security, and what about the return of security? These are just some of the issues that you might want to get advice on. Obviously, there's a reality here, and that is going to lawyers and getting advice is not necessarily the cheapest thing in the world. So you've got to be commercial about that, but that's something that we would recommend. If you have leverage or the power to do so, you should ideally ask for your terms and conditions to form the basis of the contract for the job. Now, sometimes that'll be practical, other times it won't. Obviously, it's a case-by-case basis. The larger builders are going to say no. They're going to say, here's our subcontract, take it or leave it, and they may or may not be interested in negotiating that. What are the benefits of having your own terms and conditions? Well, the first thing is you get certainty about what the contract says. If you contrast that to not having a written contract, just an oral, on the phone discussion or face-to-face discussion, there's uncertainty about a whole range of issues like what was the price that might have been agreed, what happens if there's a variation, is time of the essence, when does the job need to be done, what's the scope, etc. So you throw a lot of that aside, you mitigate a lot of that by having certainty as to those things. That in turn lessens the prospect of a dispute. You're more likely to have transparency and agreement about what the deal is. And the final point is, if you bring terms and conditions to the table, you have generally more favourable terms and conditions as opposed to either the other side's terms and conditions and contract or not having a written contract at all. And if you don't have a written contract, then the law will step in and say, okay, the terms of this, the terms of that. So you generally have a more favourable position compared to that. I just want to briefly touch upon a couple of limitations in the law regarding domestic works in Victoria. You know that there are major domestic building contract requirements if you're doing work for over $10,000 and or more than one type of work, you need to have a major domestic building contract. Having said that, generally there's no need for a builder and you're not required to have a major domestic building contract if the work is only plumbing and not other works, including structural work. And that's even if the total cost of those plumbing works is over $10,000. One quick example of this, you can't build a whole kitchen as a plumber. For example, the electrical works, cabinets and plumbing, but you could do the plumbing for a kitchen without a major domestic building contract. If there is a major domestic building contract required, then obviously a builder must be engaged by the owner and then you'll be the subcontractor under the builder. And look, there are a couple of websites that are quite useful on this issue. Consumer Affairs has a good explanation about this, goes into a bit more detail about those issues, but I'm sure you're all familiar with that. Let's talk now about Master Plumbers to standard form contracts, how and when to use them. Master Plumbers has developed 2 standard form contracts that can be used by plumbers who are engaged by clients or builders to undertake plumbing works. They're available on the website and I'll walk you through that now. There are 2 versions of the contracts. Let's just take a moment to go to the website and find out how and where you can find these contracts. So if we just walk through that now. First page here, the main website that I'm sure you're familiar with, top right corner there, a yellow circle, that's the login. You click on that, you then punch your details in, your username and your password, and you go to the membership portal. Now, if you click there under My Business, it's circled with the yellow, you'll then go to the next page, which here is a variety of bits of information and toolkits and other things that will be useful for you. The top item is the contract templates. If you click on that, you come to this page and you'll see that they're the PDF versions of the contracts. You click on those and they look like this. This first slide is the services contract for use between a plumber and a builder. And if I turn to the next one, this is the services contract for use between a plumber and an owner. So that there are 2 versions, and the difference obviously is this version here, the first version, it's when you're being engaged by a builder. The second version, it's not a builder, it's an owner. The key difference between these contracts, by the way, is that as the plumber, when you're engaged by a builder, you can make claims under the Building and Construction Industry Security of Payment Act, or the SOP Act is what they refer to it as. The second contract, as between you as the plumber and the owner, it doesn't refer to claims being made under the SOP Act. I'll come to that with a subsequent slide, but essentially that's because under the Act, you as a plumber can't make a security of payment claim against an owner. It's a no-no under the Act. They don't want mums and dads receiving security of payment claims and having all the issues that come with that. So these contracts, what's the benefit of them? Well, they're easy to fill out. They're available in Word version and PDF. You can fill them in online, or you can print them out and fill them in with handwriting. So they're user-friendly. The second point is they contain terms that are favourable to plumbers. I mean, they're not highly aggressive and unreasonable, and you're likely to have a whole lot of issues with owners and builders saying, hey, not accepting this, but they do generally look after you, and they have an appropriate risk allocation. Just by way of example, they allow for progress payments if the section's completed for that. And there's payments that need to be made by the other side, being the owner or the builder, within 7 days of each claim. Other examples of how the terms and conditions in these contracts help you and protect you: they allow for claims for variations, i.e. extra money or cost, latent conditions such as excess soil, rock, or reef materials that might be found during excavations, tree roots, blockages, drain inspections required, cleaning required, etc. You can charge that as a variation. It makes it clear that there are assumptions made by you as the plumber that things are in order, and if those things arise, they're sort of deemed variations you can charge extra for. There's also a very useful section that says the plumber assumes that the works that are currently at the site currently comply with all standards, such that if when you're doing your work you find out that actually the stormwater's non-compliant or the plumbing has some issue, well, you say to the client, hey, this isn't compliant, this is what needs to be done, here's the scope of works, here's the variation request, can I have your approval, document that, and off you go, charging that as a variation. It also makes it clear that if the client doesn't pay you, that they're liable for recovery costs, including third-party costs of chasing those amounts. That's pretty useful. So it puts you in a better position if you're going to recover monies. One other example, under these contracts, you have a right of suspension of the works if there's a failure to pay or other default. And you also have a right of termination. They're very useful tools. We'll look at those in a bit more detail. Just be a bit careful about how you use those rights. And obviously, if you're using these contracts or any other, make sure you follow those provisions quite carefully and serve the appropriate notices and do things in the right way so that you protect yourself. The short point is that Master Plumbers and us say that these are a good contract that we would recommend that you use as your terms and conditions for engagement, obviously where you can, subject to that discussion about whose terms might apply. I suppose the alternative to this is going to a law firm and getting your own terms and conditions prepared. That is another option. That's obviously a commercial matter for you. But I think the point here is if you can have your terms and conditions, put them in place, use them. And these are a very good contract to consider adopting. Right, let's move on to the guts of what we're talking about today, which is tips and tricks for getting paid promptly. I'm going to run through a range of things that I think you can do or you should be thinking about. Now, some or all of them may apply in particular jobs. It may be the case that some of them aren't practical for a whole range of reasons. Others are. So the way I'd look at this is a tool bag for you of tools you can use to try and set yourself up to mitigate the chance you won't get paid, i.e. to get paid promptly for the work that you're doing. The first point, it's an obvious one. See whether you can obtain a deposit from the owner or the builder for materials and goods that you're going and buying. This obviously mitigates the risk of non-payment. It's particularly useful if you need to spend a considerable amount up front for plumbing supplies or materials. Just one example, if you're engaged to install a large hot water system for an apartment complex, the costs of obtaining those boilers and other units may very well be significant up front. That's the kind of scenario where you might say, look, we need a deposit. We're going to spend a few $100,000 on this. We need 50% up front, 50% on delivery of the goods to the site, etc. Just note in this regard, Section 11 of the Domestic Building Contracts Act, it does provide a maximum deposit for a builder for a domestic building contract of 5% of the contract price if it's $20,000 or more, the contract price, or 10% of the contract price if the contract price is less than $20,000. Now, this limitation does refer to deposits paid or payable to a builder for domestic building contracts. So in our view, it probably doesn't apply to a plumber, CF, or as opposed to a builder for the single trade exemption concept. So I think for that reason, if you're just engaged to do plumbing works and you're not the builder and there's no issue there about that, then you can ask for effectively whatever deposit you want to ask for, 20%, 50%, even 100% upfront. And obviously that's then a negotiation with the owner or the builder who may or may not be agreeable to that. The next thing to think about, it's a variation of getting a deposit. You can ask the client to pay for the goods or materials. For example, you might be engaged by a homeowner to do some plumbing works at their house, put in a new bathroom or do some work in the bathroom. Well, you might say to them, I've got a trade account with Ream or whoever, happy for you to go and use that trade account, buy for things directly. I'll pass on the trade discount to you if you use my account, etc. What are the benefits of that? I mean, it's pretty obvious, but it reduces the cash flow pressure on you. So you're not paying for this up front and waiting to get paid when you put your progress claim in and then get paid or not, weeks or months down the track. And it reduces the risk if payment is deferred because there's less money that is outstanding if the owner's paid for these goods up front. One of the third things you should think about is progress payments. So if you charge 100% of the contract price at the end of the job or at the completion of the job, the risk of non-payment is obviously 100 cents in the dollar, and you're not going to find out till they either pay or don't pay that claim however many weeks or months down the track. So instead of getting paid all of the amount of the contract at the end of the contract, you obviously put in progress payments if you can to get paid at particular intervals over the job, whether it's weeks, whether it's months, depends upon the nature of the job and how long it goes for. But think about doing that. The benefit of that obviously is it reduces this risk, and it means that if you're not paid one of your progress claims, you can have a look at that and look at your rights to, for example, suspend the works until you're paid or consider terminating the contract to cut your losses. If you're not going to get paid for the first couple of progress claims, then why continue if you're just going to be incurring more costs and taking on more risk of not getting paid at the end. Again, a bit of a warning about this. Be careful when suspending or terminating any contract, as there is potential for legal debate about this, as to was that suspension or termination proper and valid, or is it an improper bit of behaviour that amounts to a breach or repudiation of the contract. I've been involved in a couple of claims like this at VCAT and in courts, and it can get quite messy. So be very careful before you suspend or terminate, but obviously they're useful things to consider when you're not getting paid. The next thing to think about is the use of software to get payment on the spot. So there are several software platforms or packages available for plumbers and for tradies, but generally just providers to get paid on the spot. For example, we've got this Square program that you can, software package that you can obtain that gives you the little Square device that you plug in and you can take credit card payments with. Consider something like that. There's other alternatives in the market, and you can effectively then take this software package with you to jobs, and it can prepare invoices and have you get paid by the client, by credit card, etc., on the spot. And that's a useful thing to do. So if you're not having to go and do the job, issue the invoice and wait a few weeks, obviously there's a benefit there. You're getting paid at the end of doing the job on the job at the time that it's finished. Something else to consider, taking security and registering that security on what's called the PPSR, the Personal Properties Security Register. So the concept here is if you're buying significant goods and materials, for example, hot water systems, but really anything, it could be pipes that you're ordering in from overseas, large amounts of them, etc., expensive stuff, then you may well want to have in your terms and conditions or in a special condition that applies for this job that you own those materials unless and until you're paid in full. Now that's called a retention of title clause. Now in the old days, you could have that in your contract and that'd be enough. But the law changed a few years ago. Those sort of retention of title clauses, i.e. you don't own it, builder, or you don't own it, owner, until you've paid me in full, they only work if they're registered on the PPSR, the Personal Property Security Register. So you might have that special condition. If you don't register it and the other side, the builder goes insolvent and you say to the administrator or liquidator, hey, they're my pipes or they're my hot water systems, here's the contract. First thing they'll do is say, is it registered? If the answer is no, you fail. They'll say, no, it's ours. We've got possession, it's our material, etc. Too bad, and you'll lose out. So if you've got a situation like that, where you're obtaining a large value of goods, like your pipes or your hot water system, whatever it might be, then you probably want a retention of title provision. You own it when you pay me in full upon delivery at site. There's not enough, it's got to be payment in full. And then you want to go to a law firm and have that security interest registered over the other side. And it's pretty straightforward to register it. That's a really important thing to do. And it's really important, for a whole lot of reasons, but number one, insolvency. The other side goes insolvent. You want to be able to have your security interests over the goods being upheld and not set aside. Now, the final thing here is to watch out for red flags or warning signs. And everyone talks about this in the industry, the scuttlebutt about who's gone insolvent, who's about to go insolvent, who's got problems, etc. But it's worthwhile doing a bit of due diligence on the other side that's going to engage you, particularly for the bigger jobs. If it's a company that's engaging you, consider asking for a guarantee from directors or shareholders or either the companies or the individuals that might have some substance behind them. Before you're engaged, if it's a company that's engaging you, you should do a couple of things at a minimum. One is make sure you've got the correct company that's engaging you. You never get engaged by a group of companies. It's always one company. Which company is it? Get the ACN, get the ABN, do an ASIC search. It's about $30 to do one. Have a look at it. See that there's no applications for winding up. There's no administrator that's been appointed, anything like that. Have a look for red flags there. You can also do Dun & Bradstreet and other searches to see if there are real concerns about payments, etc. But that's very much worth doing. And the final thing here is you might ask some of your colleagues about their experiences with new builders and owners that they might have worked for in the past. How'd you go? Did you get paid? Were there issues, etc.? That's before being engaged. When you've done that, when you're engaged, obviously you look out for red flags as you're going along during the project. One of them is other subcontractors are not getting paid. Well, that's obviously potentially a sign that there's issues of perhaps solvency from the builder or the owner. If there's project delays, again, is this going to be a project that's going to be unprofitable for the builder and then a problem for you because the builder will seek to have you, wear the pain of that. And lastly, of course, the old response from the builder or the owner when you put your claim in. Well, thanks for that, but you've been late and you owe me LDs, and there's set-offs for your bad workmanship, and there's other ways that will try and deny you payment. Now, I'm not trying to diminish that. Sometimes that happens, but often that's a sign that there's cash flow problems, or the builder or the owner just doesn't want to pay you and wants to get the work for free or in part for free. So watch out for that, obviously. And if these things arise, then it's worth getting advice, considering your position, and looking at things like negotiating as to payment, again, suspending the works, can you terminate, etc. does this conduct from the other side, is it a breach of the contract, etc.? What rights do they have for these alleged set-offs? And take stock of your position. Be careful what you do. I think take the time to get that advice, but you should consider doing that, particularly if it's a lot of money that's on the line. So let's look briefly at a few issues that come up, variations and latent conditions. The reason why I'm bringing them up is because if issues such as variations or latent conditions arise, they often cause disputes with the owner or the builder that's engaged you, and that will in turn mean that they're less likely to pay you the full amount of your claim. So that's why I'm bringing these particular issues up. One of the ways that you mitigate the risk of not getting paid is to be transparent and to raise issues as they come up and negotiate and agree on things like variations and latent conditions, at the time that they arise and in a way that's pretty reasonable and open. If you do that, you're more likely, I'd say to you, to not have a dispute and then therefore get paid for the work that you're doing. So what are some tips to be aware of in the context of variations and latent conditions? The first one is early notification. If you bring up the claim as soon as it arises, for example, you come across a whole lot of rock when you're doing your excavation, or you find the broken pipes or the non-compliant plumbing, if you bring it up early with the owner or with the builder, that's obviously desirable. And then once you do that, I think it's critical that you don't just rely on a conversation. How many disputes have you been involved in or heard of where it's one side saying this was said, the other side says no, it was something else altogether. So don't rely on a conversation, document it. Ideally send an email. When you're doing that, think about putting in some photographs and supporting material and explanation for what's going on with the variation or the latent condition. Have a look as well when you're doing this about what the terms of the contract say. What do you have to do to notify of the variation or latent condition? When do you have to give the notice? What's the form of the notice? What do you have to put in the notice? What are you entitled to? Is it just an extension of time, or are you entitled to extra payment and money? Have a look at that. Then once you've done that, when you're putting this sort of document together, perhaps after a discussion, notifying of your claim, obviously go through the basics here. What's the extent or scope of it? What are we talking about? How can you explain that? How can you document it? Is it photographs? Is it videos? Is it both? If it's a really big issue, should you be getting an expert in to document this and explain the extent of it? QS as to the amount of rock, etc. What's the time and money impact? Can you quantify it now or later, or a bit of both? We think it's this, it might be more, might be less. And what approval do you need from the owner or the builder? Again, under the contract, it often says you're not going to get paid unless and until the other side, being the builder or the owner, approves it in writing. So get that approval in writing. Don't just start and do the work and expect to get paid. And I think the point here is it's generally best to agree on the time and money implications of any variation or latent condition issue before you do the work. That lessens the risk of the dispute, obviously. Now, conscious of time, so we'll look briefly at when can you stop or suspend the work pending payment. So this is obviously the question: if you're not getting paid, what can you do about it? Well, it depends upon the terms of the contract. As I mentioned before, the master plumbers contracts have those rights, although you've got to exercise them properly and following those provisions as to notice, etc. But you do have the right under those contracts. If you don't have a written contract, then the law would probably say you don't have a right to suspend the works. Whether you do as determination obviously depends upon a range of things, and you need to get legal advice about that. You've got to be careful about doing this. I mentioned this a couple of times because there are often disputes about any suspension or termination as to whether it was appropriate or not. And there can be counterclaims by builders or the owner for loss and damage that arises from that. So be a bit careful and get advice, but do consider that and consider your position if you're not getting paid, what rights you have in regards to suspension or termination. So recovery of debts, how do you recover monies that are owed to you? So we've looked at mitigating the risk of non-payment, i.e. to try and encourage people to pay you, but we'll assume now that you haven't been paid. You've done the work, you haven't been paid, despite looking at all these issues and doing everything properly. For reasons outside of your control, you haven't been paid. perhaps even for reasons inside your control you haven't been paid. But that's the situation you're in. What options do you have available to you? The first one is, and of course you're familiar with this, a claim under the Building and Construction Industry Security of Payment Act or under the SOP Act. Now, generally, you can't claim against homeowners under the Security of Payment Act. Section 7 of the Act makes that clear, unless they're in the business of building domestic houses, i.e. they're a developer. So what do? You prepare a claim for putting it together. You've got to note the formalities for the claim. I'm not going to spend a lot of time on this because we could spend an hour talking about this, and I gather Master Plumbers have an advisor on security of payment claims who you can seek advice from as well. But basically you endorse the claim with the words, this is a payment claim under the Building and Construction Industry Security of Payment Act 2002 brackets Vic. Now that precise wording is critical. Then you've got to look at things like what's the reference date under the contract, i.e. what's the date on which payment should be claimed, and refer to that and make sure it's the right date. Then the VBA does have a sample payment claim form on their website. So have a look at that. You can type into Google VBA security of payment claim form. They've got a template. You can use that and tailor that. If you're not sure about how to do it, you've got any questions, do get advice, whether it's from a security of payment advisor who's well experienced in this or a law firm. Do get that advice. If you're unsure if the amount of the claim is substantial, it's very easy to get these things wrong, and it's worth taking a bit of time if it's a big claim or a claim that's significant for you. Once the claim's made, the other side needs to respond with what's called a payment schedule. They've got to do that within 10 business days. If they don't do so, then there's a process to obtain judgment and to go for an adjudication, etc. I'm not going to go into all of that now given the time requirements, but the point is if you're successful, then you get an adjudication decision. You then get a judgment which enshrines that in a court decision, and you go forward with a stat demand or a creditor's petition, which we'll look at in a minute. The benefits of security of payment, it's a quick process. It's quicker and cheaper than court action. It's, again, pretty fast. A month or two is usually how long it takes. There's the pay now, argue later idea here. So typically claims by the other side of delays or defects can't be used validly to stop your getting paid. They've got to pay you and argue that later on, which is quite useful. Second avenue for getting paid is court action. I'm sure you all know a bit about this. You go to a law firm, you get your scope quote for it, off you go, commencing in the appropriate jurisdiction. Usually there's a letter of demand that precedes that. You know, sometimes that results in getting paid, other times it doesn't. In the current climate of 6 months for stat demands, often letter of demand is not enough. You then proceed in the court or VCAT, depending upon the jurisdiction and the issues in dispute. Typically, it's more costly and time-consuming than security of payment. Of course, be aware that unlike security of payment, often the other side will come back with defences and or counterclaims of defects, set-offs, liquidated damages and other things. So you've got to be aware of that and be open to that. You might be claiming a debt of 20,000. They come back with a response saying, we deny the debt and say that you owe us 40,000 in LDs and other losses because of your poor work and defective work. And then, you started a war that you've got to go and fight in court or the tribunal for however long it takes, at obviously legal cost as well as time and effort. The third avenue is the statutory demand or the creditor's petition, sort of bankruptcy notice. Again, once you've got your judgment, either through security of payment or court action, you enforce it. Well, it's not technically an enforcement under bankruptcy or insolvency law, but practically speaking, you go away and get the stat demand prepared by a lawyer. It's issued. I've spoken about how it used to be 21 days for the other side to respond to that. Now it's 6 months under the COVID changes. So it's a long waiting period at the moment. Hence the discussion about tips and tricks to getting paid to minimise the chance that you'll be in this situation, having to look at these three avenues of potential recovery. I want to, I've spoken a bit about the pros and cons of each. I'm probably going to leave it there on the avenues for recovery, but they're the things you should be thinking of. The right approach will depend upon the amount of money in dispute, the circumstances, etc. There's no one approach that's better than the other, but generally security of payment, if it's available, is better than going to court. It's fair enough that that's the general principle there. So let's look at a couple of practical examples. The first one here, top quality plumbing. It's engaged by Peggy to carry out the installation of new drainage to her house, including the replacement of existing drains in her backyard. Top Quality Plumbing starts the work without a written contract and without providing Peggy, the owner, with a fixed price quote or even an estimate. Top Quality Plumbing encounters significant tree roots and rocks. Bill, the apprentice, asks Bob, who's the manager, what to do. Bob tells Bill, the apprentice, to hire a bobcat and get cracking on the job. So against his better instincts, the apprentice does so and he finishes the job at additional time and significant cost. The excavation of the tree roots and removal of the tree roots is done close to Peggy's house. Peggy is watching this and she's somewhat alarmed and surprised by the fact that the job is taking twice as long as expected and there's a bobcat in her backyard, but she lets it go. And then Bob prepares the invoice and gives it to Peggy at the end of the job, and the invoice is for 25 grand. So Peggy, of course, refuses to pay, saying that she thought the job would cost $5,000 at most. Peggy says she's really furious and wants to refer the matter to the VBA and Consumer Affairs Victoria. So we've got this dispute. Just a couple of observations. The first one, if there's anything to take away from today, Top Quality Plumbing really should have used a written contract with clear terms and conditions. As we discussed, it could be the master plumber's template contract with owners, not with the builder, because Peggy is not a builder. Or they could develop, Top Quality Plumbing could develop their own terms and conditions to cover off some of these issues. The next thing, look, it's fair to say that Top Quality Plumbing should have provided a fixed price estimate for the job to set expectations. So we think it's going to be, I don't know, 10 grand, assuming that your existing plumbing is in this way or whatever the assumptions are. And then when the issues arose as to the tree roots and rocks, it's the issue about variations. They should have raised the issue with Peggy, consulted with her, agreed with her ideally about the extra cost and time implications before doing the work. And then rather than just having a discussion with her and over a cup of tea in her kitchen or whatever, document it properly. So the email to her saying, hi Peggy, as discussed, this is the issue, here's the extent of it, here's our estimate for this variation, here are the photos, etc. And making sure that this dovetails with the contract, so the right notice requirements, etc. And having her, if it's required to be approved in writing, approve it in writing. You know, Peggy, when you respond and confirm this, we'll start the work and get it done, because we're conscious that you want to have the job done as soon as possible. The other thing to think about here is, should Top Quality Plumbing have asked for a deposit? If they're incurring a significant amount of money, 10 grand, 20 grand, should they say to Peggy, look, we need a deposit of 5 grand or whatever it is up front? That would have mitigated some of this risk of not getting paid if the dispute arose. And I'd say to you that if these things happened, then the chances of a dispute with Peggy and her being unhappy would have been significantly reduced. The other thing I'll flag here is bullet point number 1, 2, 3, 4. The excavation and tree root removal is done close to her house. The thing to be aware of there is obviously the structural issue. So should Top Quality of Plumbing have said to Peggy, look, because we're going to be doing this near your house, you need to get an engineer in to advise on this as to whether this could have a structural impact, etc. Because if our house had, been damaged or collapsed, would there be liability there? Yeah, probably. Would the VBA be interested? Yeah, probably. Would they have potentially gone after Top Quality Plumbing? Maybe. So they're the things that you might want to think about as well. Let's turn to the second example, Hot Water Plumbing Proprietary Limited, or HWP. It's engaged by Buildcon Proprietary Limited. It's a large building company. So they're the builder. The job is to design and install a hot water system for a 10-level apartment complex. HWP asked the builder if they can use their standard terms and conditions. The builder says no, which is hardly surprising. They're a large building company, and they demand that HWP sign their 200-page long D&C subcontract. HWP signs the D&C subcontract. After all, it needs to do so to get the job. HWP must order significant materials and equipment, including $500,000 of off-site works, the hot water units that need to be installed on the roof. HWP asks for a deposit and prepayment from the builder. The builder again says no, we'll pay you under the D&C subcontract when you've done the work in accordance with the payment clause 51, which says that we'll pay you 45 days after you submit a valid claim, etc., etc. HWP's monthly claims are rejected by the builder. after they start work, the monthly claims are being rejected. There's allegations of poor works and delays. Variations also arise due to the poor design of the hot water system by the architect and the engineer who are engaged by the builder, notwithstanding this is purportedly a D&C subcontract. So what are some of the issues that arise here? I think the starting point is it's a difficult scenario, and it's what you often face as a subcontractor. A builder will say, here's my subcontract. So you either take it or you leave it to some extent, but if you can, think about negotiating special conditions. For example, a right to advance payment for the hot water system, maybe in return for HWP providing a bank guarantee or security. So the builder might say, look, I'll only pay you under the contract when you've done the work and it's all legit and checked out. You put your claim in, etc., and I assess it. But you can get prepayment, but builders will often say for offsite works of significant value, I don't want the risk of you going insolvent. I need security so that if you go insolvent, there's a problem, etc., I can call on that. So they usually say, if you want 50% of the payment for the hot water system in this case, we need a bank guarantee for that amount that we can draw upon if there's an issue. And obviously you talk to your financial institution about that. Obviously there's a cost to that, but there's a benefit there as well of getting the advance payment. So that's something to consider. Also, you should consider right to suspend work if not paid. Can you ask for a special condition to that effect? Look, ideally you'd ask for it and get it, but I think it's unlikely that a large builder would give it to you. The next issue is, should HWP have obtained legal advice on the D&C contract? Pros and cons of that. In an ideal world, yes. The reality might be, well, they're not going to negotiate much anyway, so what's the point? But I think the better view is, it's a big job, you should get advice on it. You should work out what your appetite for risk is, what special conditions you want to ask, what things you want to negotiate. You know, things like a cap on liquidated damages, a cap on liability, you know, deposits, advance payments, etc. What about the rights of HWP to suspend the works or terminate the D&C contract when they're not getting paid? You have to look at the terms of the contract, given its build cons, large design and construct subcontract. They probably won't have a right to do that. Be very surprised if it had a right there, but it's worth looking at and getting advice on. With the defects claims that are being raised by the builder, I think that it's important that HWP gets advice and considers whether or not these things are legitimate or not. Consider whether or not you want to engage an expert. If you want to get advice, engage an expert, do it through a law firm, get the benefit of privilege over it, because you might get a report back which says actually what they're saying is right, or it's worse than what they're saying. It's a bigger issue, you're liable for it. Well, you wouldn't want that to be obtained directly by HWP. If it was, when a dispute comes, that's discoverable, i.e. you got to hand it over to BuildCon and they'll use it against you. The variations claim, again, you'd look at the terms of the contract. How should these claims be made? What's the process? Is there a right to extra payment or just an extension of time? And without, speculating too much about what large building companies have in their subcontracts from time to time, the general position is pretty tough. Usually it's time, not money, and subject to rigorous notifications, approvals, etc. So you'd have to look at all of that. You'd also consider a security of payment claim in this situation, because you're bringing that claim, particularly towards the end of a job. These arguments about defects and delays generally can't be used by the builder, BuildCon, to stop payment. They've got to pay you, and then if they want to, they can sue you later to get this money back for the alleged defects and delays. So that's worth looking at, get advice about that. And then just flagging as well, situation like this, there's likely to be a dispute about defects, rectification of those defects and retentions / bank guarantees that HWP may have provided. So be aware of that. You should be thinking about that too. And that'd be something that you'd want ideally to be in any special conditions, regulating that properly. When does the builder have to hand back half the retention or security? What about the other half? When can they draw on it, etc., to limit those rights? Because you can be sure that the D&C standard subcontract is going to be pretty unfavourable to the subby on those issues. So that's it. Time for questions now, and I'll finish with that slide, but happy to take your questions and try and answer them.
Thank you very much, Richard. Much appreciated. Have we got any questions from the group? Just Send through your questions in either the chat or the Q&A section. I really appreciate your time today. It's a lot of valuable information in that, a lot to digest. So I'm guessing a lot of people are probably going to wait for the recording to come through and have a second look. We've got a question that's come through. Is there a protection available if you're contracted to a JV if the JV was to collapse?
Yeah, great question. The easy answer is it depends what the contract says. But I suppose if a JV was to collapse, if the principal was to fold, then they'd be in administration or liquidation. If you're contracting with the JV, i.e. a company or a partnership, then you'd have a claim against the administrator or liquidator. You probably wouldn't get much out of that. So you'd be looking at the things that we discussed today to mitigate the risk of non-payment. And obviously non-payment's more of an issue when the counterparty, i.e. the builder or JV, falls over. If it falls over, well, you put your claim in with the administrator or liquidator, and surprise, surprise, the answer will be the other side doesn't have any assets and you'll probably get nothing and you're not secured. So what can you do about that? Well, the things that we discussed today, I'd be looking at, for example, having security over goods that you're buying and registering on the PPSR for those items of goods and materials, so that if the JV was to fall over, you could enforce those security rights against the administrator or liquidator and seek to have those goods returned to you or retained by you, as the case may be. So that'd be some of the things I'd be thinking about. Otherwise, your progress payments, putting those in and looking to get paid on an ongoing basis rather than waiting for payment at the end. I mean, that's pretty standard, but that's something you should look towards as well.
Fantastic. Any other questions out there from the audience? And Richard, if anyone's got any questions they want to take offline, you're happy for people to contact you via the details that are on the screen?
Yeah, look, absolutely. Drop me an email, put in a phone call. Happy to discuss with you. Obviously, it's a pretty important topic. I think, one of the views on this is, well, don't do the job, you don't have to worry about it, but that's not the answer. You need to get out there and carry on your business and do your work, and you want to try and maximize the chance you'll get paid. And hopefully this has been useful today, particularly in light of hopefully some more uptake in the industry and some removing of those restrictions and getting back to COVID normal.
Yeah, we've just got another one come through. If you have a contract in place, including the works, and the client, brackets real estate agent, refuses to pay, can you list them on the asset bad debt site as it's too small to engage legals?
Sorry, Daniel, I didn't quite catch you. For some reason, there was a bit of interruption in the stream for a moment. Could you just repeat the question?
If you have a contract in place, completed the works, and the client, a real estate agent, refuses to pay, can you list them on the ASIC bad debt site as it's too small to engage in legals?
It's a good question. I don't really know the answer to that. I'm not familiar with the ASIC bad debt website. And that's the problem. If a claim's quite a small one, what do you do about it? And that's a commercial matter. With some of those claims, if VCAT is the jurisdiction, then you could always go to VCAT and bring the action yourself to seek to recover it. You could always go to a law firm and they could knock out a letter of demand for a few $100s. I mean, that does start the cost if it's a small debt, but you can consider that. The other thing you could think about is whether you have right to security payment claim. You probably won't if it's a domestic job for a homeowner and the agent was acting as the agent for the homeowner and it's just a mum and dad. But they're the things that I'd be thinking about. The ASIC bad debt website, yeah, look, I'm not familiar with that. I think I'd give them a call and ask them what they say about that.
No problem. Any other questions from the audience there? We've got time for one more. All right, well, while we wait for see if any last ones come through, just want to again extend our appreciation on behalf of Master Plumbers and all the people that are tuned in today. Just for actually, I take it back. I just saw your Hawks Cup. I take everything back. No, well, thank you very much for your time. Really appreciate it. And to everyone listening, keep your chin up. Things are going to turn around soon, I think, and hopefully we've got our fingers crossed for some good news on Sunday. And if there's anything you need from Master Plumbers, get in touch with a member of the team. We'll help you in whatever way we can. And again, if you need to get in touch with Richard, his details are on the screen there. But thank you everyone for tuning in. We'll try and put forward some more valuable content across the next couple of weeks. If there's anything you want to see in particular, just get in touch with us. And yeah, we'll see you next time. Have a great weekend.
Thanks very much. Cheers.